So another federal court ruled that the federal laws on possessing machine guns are in fact a violation of the Second Amendment. But AG Bondi and the Trump administration continue to argue against this 2-way win that we got in this case, and now it's heading to oral arguments in just a couple weeks. So let's break down what is happening. Now, before we jump into this video, if you want to support the channel, one of the best ways to do that is to simply subscribe to the channel, and then also double check to make sure YouTube is not unsubscribed to you, because they love to do that, and drop a comment down below because that tells the algorithm that you appreciate this type of 2-way content and it should share it to more people. So as I mentioned in the intro, a federal court recently dismissed a machine gun possession charge using the Second Amendment and the Supreme Court's recent decision in Bruen. This was a huge win, striking down machine gun restrictions as a violation of the Second Amendment. There have recently been 2 federal district courts who have dismissed machine gun possession convictions based on a finding that they do violate the Second Amendment. The most recent ruling came in a case out of Mississippi, a Mississippi district court, and that was issued by Judge Carlton Reeves in a case called U.S. versus Brown. Currently, that case is being appealed to the Fifth Circuit, but that was also based on a prior ruling in another case that we're talking about here in this video, which is being appealed to the 10th Circuit, and this is the U.S. versus Morgan case. In this Morgan case, a federal judge in Kansas found that a machine gun possession charge was unconstitutional in violation of the Second Amendment as it applied to Mr. Morgan. This Kansas Morgan ruling has now been appealed to the 10th Circuit by the United States government, and now the 10th Circuit will hear arguments in this case in just a couple weeks on July 8th. However, one unfortunate development in this case is that the Trump administration still continues to argue against the Second Amendment, against the striking down of these machine gun possession charges. They're still making anti-gun arguments, not just in this case, but also in the Fifth Circuit in the Brown case. And unfortunately, this will probably continue unless we make a lot of noise and get the Trump administration to change course in these challenges like they did in other challenges like the Peterson suppressor challenge and a lot of the rifle bans also out of the state of Illinois. Now, the facts surrounding this case are that Mr. Tamori Morgan was charged with 2 counts of possessing a machine gun in violation of 18 U.S.C. section 922-0. He was charged with possessing 2 different firearms, one of them being an AR-15 and then also a machine gun conversion device, which was a Glock switch. It's the possession of those 2 items that got Mr. Morgan charged and convicted of possessing machine guns in violation of the GCA, and in response to that, he moved to dismiss those possession convictions based on the Second Amendment and what the Supreme Court recently said in Bruen. On review, the federal district court judge found that the defendant argues that 18 U.S.C. section 922-0 is unconstitutional facially and as applied to him. Defendant first argues that under the first step of Bruen, the plain text of the Second Amendment applies to his conduct of possessing machine guns. The government argues to the contrary, pointing to language in Heller that suggests the unconstitutionality of machine gun regulation would be startling and that the Second Amendment only applies to weapons that were commonly used by law-abiding citizens at the time of the Second Amendment's enactment. When looking at the Supreme Court's precedent in Heller, the court here actually found that the government relies on Heller to argue that machine guns are not covered by the plain text of the amendment. The Heller language cited by the government is unavailing. First, the government's interpretation of Heller relies exclusively on dicta. Machine guns were not at issue in Heller. Second, the court said that the government's interpretation would run directly counter to the essential analysis in Heller. Just as the Fourth Amendment applies to modern searches, the Second Amendment applies to arms that did not exist at the country's founding. So the court here rejected the arguments that were made by the federal government. At that time, it was the Biden administration arguing against Mr. Morgan, and they found that the Heller, rationale that was tried to use in this case was unavailing and did not support these type of machine gun possession convictions. The judge also stated that suffice it to say that the weapons at issue in this case are bearable arms that under Bruen's first step are covered by the plain text of the Second Amendment. The judge then reviewed the federal government's historical analogs to see if there was any tradition or history to justify these restrictions, and essentially the court found that the government did not meet that burden under Bruen. Now, it's important to note that in this Morgan case, the Biden administration at that time put forward very little historical evidence to try to justify these federal laws. Instead, they kind of got lazy and were just trying to argue that machine guns are not arms under the plain text of the Second Amendment. But once the court found that they are arms, that they are protected arms, and moved on to the historical analysis, the federal government really didn't try to bolster up that side of the argument. So inherently they lost because they did not have a lot of historical support. Well, after losing at the district court level, the federal government, the Biden administration at that time, decided to appeal to the 10th Circuit, asking for the 10th Circuit to reverse that lower court ruling. Mr. Morgan responded to this in the 10th Circuit, and he argued that the narrow decision by the district court should in fact be upheld. In the beginning of his brief to the 10th Circuit, Mr. Morgan's attorneys point out that the federal government is now also trying to pull a fast one. They're trying to supplement the arguments and include in more historical support, which they did not include at the lower court level. In front of the district court, like I mentioned, they only had 2 pieces of historical evidence, but now when they're appealing to the 10th Circuit, they're trying to add in more because they don't want to lose on that aspect of this case. Mr. Morgan's attorney argues that the 10th Circuit should reject and ignore all of this new historical examples that are being supplemented into the appeal because the review of the 10th Circuit should just be looking at what the district court reviewed. Did they reach their proper determination based on what was presented to them, not based on new arguments that are now being submitted at the Court of Appeals level? They also emphasize that this was an as-applied decision and that it only applies to Mr. Morgan and his specific facts. The district court did not close the door on other cases and other facts coming up, after this Morgan case, but right now this decision applies specifically to just Mr. Morgan. Now, currently in this case, the Trump administration has control of the federal side, so they get to decide how this case proceeds forward. The appeal was filed by the Biden administration, but the Trump administration gets to follow up on this. And despite the new 2A task force established by AG Bondi in the Trump administration, they're still making anti-gun arguments in this case and also in the Brown case in the 5th Circuit. In their recent brief, the Trump administration argues in this Morgan case that contrary to the district court's holding, Section 922O's prohibition on the possession of a machine gun is consistent with the Second Amendment. They argue that machine guns are not in common use for lawful purposes like self-defense, and Section 922O is consistent with the nation's historical tradition of regulating a variety of dangerous and unusual weapons. Morgan fails, they argue, to effectively rebut the government's arguments. He wrongly contends that the government failed to preserve various arguments on appeal. He tries to avoid the Supreme Court's clear holding that the Second Amendment does not protect firearms not typically possessed by law-abiding citizens for lawful purposes, and he advocates an improper standard that will require the government to identify founding-era laws regulating firearms based on their rate of fire. The court here should reject these arguments and reverse what the lower court said. The Trump DOJ also made similar arguments recently in the 5th Circuit in that Brown appeal, which is also moving along in the process, but still you have there the Trump administration arguing against the lower court's decision, striking down these machine gun possession charges. So it's unfortunate that AG Bondi and the DOJ and the new 2A task force are still kind of letting maybe these Biden administration holdovers proceed forward in this case, or maybe they just really believe that machine guns are not protected arms, and that's why they're allowing these proceed forward this way on appeal. My hope is that the 2A task force eventually steps in sooner rather than later in these cases and puts an end to these types of arguments. But unfortunately, right now, the 10th Circuit is kind of just taking what the Trump DOJ is continuing to argue. And now these cases are heading to oral arguments in just a couple weeks. On July 8th, the 10th Circuit will hear arguments in this case, and then after that, decide. So share this video around and make noise so that the administration steps in like they did in some of these other cases and puts an end to these anti-gun arguments that they're making in the Morgan challenge and also in the Brown case. These are strong wins that I would love to see stick, and it would also go a long way to open the door to make similar arguments and similar challenges and lawsuits to stop other types of machine gun conviction charges. Again, would open the door for more as-applied challenges, and that would go a long way to also striking down these GCA machine gun charges. So like I mentioned, the 10th Circuit oral arguments are set for July 8th, but as of right now, the Trump administration is still arguing against the machine gun possession win that we got. And so they're still trying to get that reversed, not just get reversed in the 10th Circuit, but also the other win that we got, and they're appealing that in the 5th Circuit. So we're going to be looking forward to listening to what happens at the oral arguments and what the Trump administration argues at those oral arguments. Are they going to shift at all? How is that going to develop? And we're going to see what happens in just a couple weeks. And as we get more information, I will let you guys know. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And don't forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.